Good afternoon. On behalf of the Center for Community Progress, I'd like to welcome you to today's webinar. My name is Crystal Stevens, and I serve as the Program Associate for National Leadership and Education here at Community Progress. Community Progress webinars equip participants with the building blocks to understand and solve tough challenges related to property vacancy, abandonment, and deterioration. For today's webinar, we are joined by Matt Kreis. In addition to acting as the organization's in-house counsel, Matt works closely with Community Progress' national and place-based technical assistance teams to help communities evaluate and reform the laws, policies, and practices related to vacant, abandoned, and deteriorated or problem properties. In this role, Matt applies his expertise in state and local law and policy related to housing and building code enforcement, delinquent property tax enforcement, and land banking and other land reuse systems to help state, local, and community leaders across the country identify how to mitigate the harm imposed by problem properties on neighbors. Before turning it over to our speaker, I want to mention that we will allow time at the end of the presentation to answer questions. If you have questions during the presentation, please click the Stage tab on the right side of your screen, select Chat, and type your question into the chat box. We will share presentation slides and a video recording of today's presentation in the week following. If you experience any technical difficulties, please send an email to myself, Crystal Stevens, at cstevens@communityprogress.org. And with that, I'll turn it over to Matt.
Good afternoon, at least to those of you in the Eastern time zone. My name is Matt Kreis, as Crystal said. A huge thanks to Crystal and our whole team at Community Progress for supporting the administration of this and all of our webinars that we're able to do and bring to all of you. So I'm really excited to talk to you guys about property tax foreclosure. I know I'm kind of a nerd. Let's get that out of the way. But before we dive into the content, I do want to set the stage, a couple items to set the stage for our discussion today. So I am going to present for a little while, as Crystal said, and we will reserve time at the end to answer questions. I want to point out my colleague, Libby Benton, our senior counsel, is here to help monitor the comments and is another great Community Progress resource for all of you if you have questions on some of this material after the webinar. So we will be relying heavily on our recent policy brief for this webinar. So just want to make sure folks that are following along know that. So if you had the chance to read it, you've got a leg up on some of the others. So as we discuss this case about property tax foreclosure, right? And specifically, the case itself is about the system in place in Hennepin County, Minnesota. I do want to be clear. One of the challenging factors in putting together a national webinar on this topic is that it impacts different states in different ways. And so the analysis and the options for reform that we present may apply or may not apply in a little bit different ways for each of you. Indeed, several states are going to need to make some fairly significant changes to their state law. Others may need only minor or no tweaks to state law, but may need to look closely at local ordinances or practices. And many states, in fact, likely even possibly a majority of the states, may not need to make any direct changes as a result. That said, we at Community Progress firmly believe that the Tyler decision presents an opportunity for all states to review their property tax systems, right? And to raise some important questions. Is my system, this entire system of property tax administration, is my system equitable and fair? Are there things we can do to better mitigate or prevent displacement or perpetuate or stop perpetuating the cycle of poverty, right? How, and most importantly for Community Progress, how or can I use that property tax system to reduce the harm and inequitable impact of vacant and deteriorated properties on neighbors and the community, right? So as a result, when we get to the questions, I want to be realistic, right? We're going to entertain all of those that we can, but I urge you to consider also, in addition, whether reaching out to me or Libby or others that you know to set some time up to chat through these specific issues facing your state and your community might be fruitful as well. We're here for that, and we're excited about doing it. So before I dive in, one last thing, I want to say a big thank you. Over the last several months, we have been convening some incredibly smart lawyers and practitioners around this issue. And we've met with folks on webinars, on Zoom meetings, in person, and All of these people have helped to shape our understanding of the case, identify some of the impacts we may or may not have considered well in different places, and we continue to learn from all of them. So, throughout those conversations, sometimes we agree, sometimes we don't, and that's good. So there's too many to name here, but needless to say, I think what we've learned overall from them puts us in a better position to be helpful to you all. So thank you to all of you very, very much. I want to say particular thanks to Frank Alexander, who's helped me think through a number of things as well in this. So without further ado, next. Thank you. A little bit about the Center for Community Progress. This is our mission: to foster strong, equitable communities where vacant, abandoned, deteriorated properties are transformed into assets. So why are we so focused on a case about tax foreclosure? It's this system, the property tax system in general, and especially the final foreclosure event that has had deeply historically inequitable impacts on communities across the country that are really impacted by vacancy and abandonment. So we're urging our partners to really take a look at this system. Yes, as it relates to that, but we'll get into some of the other things that we think are important to consider as well, given the potential harm that the system can cause. Next. How we do it, here's just a few things that we do. For those of you that aren't familiar with the organization, we educate people, we advocate for equitable policy and practice change, and we deliver a lot of the customized expert guidance to be able to show folks how they can do it a little bit differently. Next. So we're going to give you just a little bit of background first. So what is property tax foreclosure and what is this Tyler case all about, right? Next. As we go through this, I want to set the stage for a couple of terms. I am a lawyer, and so obviously spend a lot of time trying to figure out how to define terms properly. I already gave you one that's not on here. When I say property tax system, I mean the entire system, from assessment to collection and billing to enforcement of unpaid taxes, all of that, right? But when I use the phrase delinquent property tax system, I mean the system where we're actually enforcing those taxes that go unpaid, usually after a period of years. Okay, and I want to talk through this. So I'm going to use the term property tax foreclosure or foreclosure in this. There are a range of different processes that a lot of counties and municipalities and even states use, primarily where there's tax delinquent properties. They use these processes to extinguish the owner or interested party's rights to the property. And then at the end of the foreclosure or enforcement event, the property is then sold or transferred to a new owner, right? So that's what I mean when I say foreclosure. At the end of the foreclosure, in many jurisdictions, there's a foreclosure sale. And when I use that term, I mean a public auction at the end of the foreclosure where the property is offered for sale. The minimum bid at that public sale is the total public debt, and we'll get into that a little later. And the winning bidder pays the most above the minimum. I'll use the term strict foreclosure. And that's what I mean when there isn't a public foreclosure sale and the local government maybe takes title to that property without offering the property for sale. And they take direct title to the property at that point. Two other quick terms: equity. We're going to hear the term equity used a lot. You've heard it probably from other forums to talk about home equity in the context of the Tyler case. Which refers primarily to somebody's interest in the financial value of the property. We're also going to be using the term more often in our own terms to use the concept of fairness, right? So I want to acknowledge the dual meanings there and let you know where we're generally meaning when we use the word equity. And then finally, surplus. This is going to be an important term throughout this, and I'll fall back on this to describe any excess value in the tax foreclosed property that exceeds the total amount of the taxes and the public debt owed at the end of the foreclosure event. So hopefully that's enough to sort of get us a good grounding. Next. As I mentioned earlier, there are hundreds of systems across the country. All 50 states have a slightly different system, and within that state, different counties have different systems. Sometimes municipalities have their own system. There are just hundreds of different ones across the country. And so it's difficult to really to talk about all of these types of issues and things like that without acknowledging how different some of these cases are, or how different some of these systems are. One of the things that we do in a recent publication called Reimagined Delinquent Tax Enforcement, and I want to point to my colleague, Kim Graziani, who is the author of that. We try to perhaps overly simplify, but in an attempt to try to boil it down to when there are unpaid taxes, most governments do one or the other or both. They either sell the property to satisfy the unpaid taxes or to resolve the delinquency, or they sell the tax debt or tax liens or certificates to a private party who can then gets the right to collect those taxes, earn interest potentially, and perhaps even seek title to the property through a foreclosure action themselves. So that's just an attempt to sort of level set. Next. So what is this case about? My hope is that folks who are attending this webinar have already spent some time reading the case or reading a little bit about the facts of the case. So I don't want to spend a great deal of time on this. Right. In the case, 94-year-old Geraldine Tyler stopped paying taxes on her condo in Hennepin County, Minnesota. The county repeatedly sent a number of notices to Ms. Tyler. And then, as summarized in the case, they followed the letter of the law. They let her know after a period of about 5 years or so of not paying the property taxes. She accrued roughly $15,000 in unpaid taxes, interest, and fees. At the end of that period, about 5 years, the county took title and possession of the property, as they were able to do in state law. About 15 months after that, they sold the property for $40,000. And Ms. Tyler then sued the county saying, hey, I should get the difference between what was owed and the amount you sold it for after taking title to the property. And that's where the lawsuit came. So the Supreme Court took up the case after the Eighth Circuit affirmed and upheld the Minnesota's system of doing so. And again, I'm speaking very, very freely here. So, but at that time, then Ms. Tyler appealed it to the Supreme Court. And ultimately, the Supreme Court ruled that by allowing the county to keep the surplus from that property sale, Minnesota law violates the takings. Ms. Tyler makes a case for a takings clause violation of the Fifth Amendment of the United States. In other words, she had a property right to those excess proceeds or that surplus. Next. So now we're going to dive into, that's a very, very brief overview of the facts of the case, a little bit of a hint of the ruling. We're going to dive here into the analysis. I want to be clear here, it's not a retrospective analysis, right? There are going to be consequences of the Supreme Court's decision that folks are going to have to grapple with. And that's going to be a really big conversation in some states that have a system in place like Minnesota's. That is not the purpose of this webinar. We're not going to be spending a good deal of time on that. We're looking prospectively. So our analysis and our thoughts about what can happen going forward are going to be thinking about what can we do to reform the system that we have in place to both comply with Tyler and to address some of these other things that we think are important. I want to also point out that not everybody may agree with everything we put out there, and that's okay. We're looking forward to the conversation. We think this is our best compilation of what we believe the case says and what we think folks should be thinking about when they're doing so, but we're absolutely willing to engage and go back and forth on some of those other things that folks think might differ from where we're coming out. So next. So what do we know? And the answer to that is not a ton, right? We know that local governments can still foreclose and then sell or transfer tax delinquent property to satisfy that unpaid tax debt. We also know that they must provide an opportunity for property owners to recover any value in the property that exceeds the total amount owed to the government, right? That is definitely what we know. One of the things that we wrote in the policy brief is that this sort of limited view of what we know is that this is really just a debt collection tool. And what we know is that the local government can collect what is owed to it. And what the Supreme Court said is, but no more. And so that's an important concept to remember as we go through this analysis. So that's about the only thing that I think we know. And so if we turn to the next page, what we've done is developed a series of questions. We've identified 5 of them that we believe the court didn't answer, but are important for folks to get a handle on. That does not mean that these are all of the unanswered questions that are out there. We just believe that these are some of the most important ones, that thinking through these questions and trying to answer them to the best of your ability for your own jurisdiction are going to be really important in helping you come to some answers for what changes do we need to make, if any, right? So the first question there is, how do governments really value tax delinquent property for the purposes of determining whether a surplus exists, right? And so The decision strongly suggested that at the end of a tax foreclosure, that a public auction, or as we're calling it, a foreclosure sale, of title to the property is permissible to establish the value of the property, right? And so I just want to make sure that that seems to be, from the best we can gather, that that's probably the safest route for folks to be able to go to offer some kind of a foreclosure, like a public auction at the end of it. Now, to be clear, the court did not expressly impose any other limitations on how tax delinquent property could be valued. There could potentially be an appraisal by the foreclosing local government, right, to be able to assess the value of that property. Now, the difference between a foreclosure sale and an appraisal, a public auction type of format is maybe rarely expected to generate full market value, while an appraisal is designed to get to just that. So there are some differences between the two things. And I also want to talk about, because of the court's discussion and the way that public auctions are often treated, additional methods like appraisals or things may carry additional risk that the mechanism could be challenged by a former tax foreclosed owner. So that's the first question we tried to answer. Next. So if the local government does foreclose on the property and they take title to it, or title passes, the Supreme Court has suggested that this is a taking of any excess value without the process to claim it. So on what date is that taking occur? Right. So we're saying the date that the property was sold or transferred, or the former owner's right to redeem the property and prevent the foreclosure were extinguished. Whichever one of these things happens last. Right. So therefore, we sort of believe that that valuation, right, should take place on or as close to that date as reasonably possible. And look at the Tyler case, where there was about 15 months between when the title passed to the county and when the property was then sold. Right. And so there's always a lot of questions around what could happen to the property in those 15 months. Was anything done to take care of or preserve the property, which was, by all accounts, as we understand it, sitting vacant over that time, right? So there's a lot of questions. So when does the taking occur matters in terms of when we're able to value it for purposes of doing that, and trying to do so as close to one of those dates as possible makes a great deal of sense. Next. So let's say we do get some surplus. There's excess proceeds, or that's excess value in the property, right? And let's say we have a foreclosure sale. How should that surplus be distributed? One of the things that we think makes the most sense and is sort of low-hanging fruit here is we have mortgage foreclosure statutes on the books in most states. And most of those statutes pretty adequately take care of how do we deal with surplus in a foreclosure action. And so pointing you to those particular statutes might be really helpful in terms of, as you're thinking about reform, what can we think about? One thing the court touched on, the Supreme Court touched on in its decision, was how should those statutes who should be able to get the surplus? Certainly, the court made clear that the owner, the former owner, should be able to claim any excess proceeds or excess value in the property. But we also firmly believe that any party that has an interest in the property, maybe a mortgage holder or other lien holder, should be able to claim surplus. And many state mortgage foreclosure statutes have that account for that in their own procedures as well. So unclaimed surplus should go into escrow, and there should be an opportunity to claim surplus. But it's really important that, to the extent that there is surplus, it's got to be accessible. It's critically important that the notices that go out from the notices that you're going to go out for the foreclosure and all of those things very clearly articulate what happens with the surplus and how folks can take it. There's always a fear that when we put these systems in place, that those who are the most vulnerable or have the least access to or trust in that system are not going to be able to avail themselves of these tools to, in this case, try to claim that surplus and get any of that potential value that might exist. We'll get into some of the specific policy recommendations for how to address some of this in the next section, by the way. Next slide. Unanswered question 4. This is a big one. Are request sale requirements permissible? In the court case, in the Tyler case, the Supreme Court discussed and did not overrule a 1956 Supreme Court decision called Nelson versus New York City. In that case, the court found an ordinance requiring a property owner to file a timely answer in a foreclosure proceeding for unpaid water bills, or that owner would risk forfeiting the right to future surplus. The court found that that did not amount to an unconstitutional taking. And the court went into some specific analysis that we get into in our policy brief just a little bit. We believe that the discussion of Nelson certainly leaves open the possibility that a state statute or local ordinance requiring property owners or interested parties to request a public auction in the foreclosure action or otherwise make a claim of surplus prior to the transfer of that property or risk losing that right, it may be permissible. But we do want to point out that the Supreme Court in this case, in its discussion, distinguished Nelson, but we don't believe that it directly assessed the adequacy of the New York City ordinance. And that is that's not a saying that they would have necessarily, but we don't know. And so it distinguished the ordinance from the Minnesota statute, where the court found that there was no opportunity for owners to claim surplus. So it's unclear to us in the future how the court or even lower courts would assess the adequacy of such a request sale requirement in the future if a former owner or interested party failed to make such a request and the local government or new owner. So tricky spot here, and I know everybody wants a settled, detailed answer. The answer is, if you want to rely on the Nelson method, the court certainly leaves the door open, but there's risk involved, in our opinion. Next. And our last unanswered question for this part, but by no means the last unanswered question raised by this opinion, are tax lien buyers potentially subject to liability post-Tyler? So we believe the answer is yes. There are several states where private tax lien or certificate buyers purchase the debt and then convert that debt, or eventually after the owner fails to redeem or another interested party fails to pay the debt back, they're able to convert that debt to a deed without a mechanism to generate or return any surplus or excess proceeds to the former owner or interested parties. We do believe that a claim for an unconstitutional taking has occurred is still a valid claim. Certainly, we believe that there's still liability out there, or risk of liability for local governments, counties, and foreclosing units, maybe states, and potentially even for tax lien buyers in that certain situation. Next. All right. So, not just as a result of Tyler, right? We believe that property tax systems need bold and substantive reform to ensure property owners have every conceivable opportunity to avoid tax delinquency and tax foreclosure in the first place. For those properties that become vacant and do fall into tax delinquency, it's really critical to reform and leverage this process, the tax foreclosure process, to responsibly steward those harmful properties to new responsible owners in support of community priorities. So the policy options that we're going to present in the next section of the slide and that we talk about in our policy brief, right, are focused entirely on getting these prospective solutions out there. And again, this is going to differ from jurisdiction to jurisdiction. I want to be clear that this next section isn't just about how to make your system more safe to a Tyler challenge. It's also how to think about the terms of that phrase equity that we talked about. How can we make sure that once we do go down this path of foreclosure, we've tried everything we can to keep homeowners, and especially those vulnerable homeowners that live in lower income communities and all too often are located in predominantly communities of color and Black and brown communities across the country. I want to make sure that we get across there that there's a lot of different factors we need to think about, but this is meant to cover a whole series of options, but also to help you with your protect you from Tyler stuff. So number one, or next slide. So that's a good segue into our number one idea here, which is to help vulnerable property owners avoid tax foreclosure. You guys have probably seen a lot of this to the extent that you've read any of our materials a lot, or followed other great organizations out there that are advocating for these types of things. But we've got to be able to have property assessments, first and foremost, that are fair, accurate, sensitive to market realities, and historical context, and understand the inequitable burden that high assessments have had all over the country. And there's research out there that shows it happening in a lot of places. There's some really good research that shows the result of inequitable assessments in Chicago, for example, where I'm from. So something to be really sensitive to. We should be able to increase property tax exemptions, including especially homeowner exemptions for senior, for disabled folks, for legacy owners, right? To limit the possibility of the local government foreclosing on those lower income occupied homes. We should adopt readily and accessible circuit breakers to reduce the tax burden for lower income homeowners. Now, these could include complete exemptions for households that earn less than locally established property rates. Detroit does something like this with their HOPE exemption, or partial exemptions for lower and moderate income households. We should allow payment plans to ensure owners can spread out property tax payments over more manageable months, or sometimes even years, especially those owners whose property taxes are not paid through an escrow account connected through other mortgages. And I want to acknowledge, I know that payment plans are administratively a serious burden, and that many times they don't work, but they do work for a number of other folks. And I want to highlight the importance of being able to offer owners that. We also need to allow heirs of deceased property owners living in the subject property to qualify for similar exemptions, circuit breakers, and payment plans as the owners on title of the property might, right? It's a real gap in our system, and we see it in a lot of different places across the country. And then finally, just simply reducing interest rates charged on delinquent property taxes can have a really big impact on people's ability to get out of delinquency and avoid that ultimate enforcement event. Next. Something Community Progress has long been articulating and is continually looking to evolve as we try to talk about eliminating the sale of tax liens, which is especially true for vacant properties, right? It's really important in the context of those vacant properties where the most effective intervention is to transfer the property to a new responsible owner with insurable title, which we'll get to in a minute, as opposed to selling the debt and waiting for a private investor who may or may not, in certain circumstances, choose to acquire the title, leaving that property cycling through an inefficient system year after year. Many state statutes that authorize the sale of tax liens, in fact, also do not have a process in place, like a foreclosure sale, to generate surplus proceeds, or for a former owner or interested party to claim such proceeds. Or if they do, it's not well used or a strong mechanism for those folks and could be challenged. Two states that pop into mind just off the top of my head are New Jersey and Illinois, where I'm from. Next, create a judicial tax foreclosure system. We talk about this a lot. A judicial tax foreclosure system that has judicial oversight, that results in, that has full constitutional notice of the foreclosure and sale, where the judgment includes all of the unpaid taxes, interest, costs, fees, and other public liens and charges, like code enforcement liens. We'll get to that in just a little bit. So it's got to include as much as we can, like whatever the local government or the taxpayers are expending to take care of that property should be lumped into that judgment. This system redemption rights should expire on the date the foreclosure sale is finalized. So it should happen before that sale, the redemption, instead of after the sale. The public auction is probably going to be the cleanest mechanism at the conclusion of the foreclosure to determine surplus. And as we mentioned earlier, there's certainly some avenues to explore there, but if we're talking about the cleanest, safest mechanism, public auction is probably the best way to do that. And then finally, a final court order is going to be needed to approve the transfer of the property. What does this type of a system get you? Well, certainly it makes sure that there's adequate oversight to a process, right? The concept of notice is really critical. And all of these things are really critical because what we want at the end of this process is insurable title. And getting insurable title and putting in place a system like this is absolutely a policy question for folks to think through. It isn't necessarily cheap. and it isn't resource efficient always to be able to put all these issues in place. But title insurance is really important. It's needed in most cases to secure financing for acquisition, for repairs, for construction, right? To obtain such a policy to tax foreclosed property, insurers need to have confidence that the right process was done, that notice of the foreclosure met minimum standards for due process, right? The alternative is we don't bear the upfront costs, and the properties that are offered at the end may not have insurable title. And that therefore may reduce the pool of interested and qualified purchasers. It may increase the likelihood that the property could become tax delinquent again in the future. If we've got a pool of property owners who didn't understand that that was something that they had to go through and need to walk away. Having insurable title also has the added benefit of offering emerging or newer neighborhood developers a better opportunity to access some of these vacant and abandoned properties that go through this system by reducing acquisition and holding costs associated with acquiring some of these tax delinquent properties through the tax foreclosure system. Next. Reform should also publicly clarify those procedures to distribute the surplus. I touched on this earlier, right? Which is the need to be very clear post-Tyler, and we should do that anyway, that to the extent that there's any surplus that a former owner can claim, it should be very clear what those processes are. If we have a judicial system, that surplus should be held in escrow through the court and distributed to the owner and interested parties upon receipt of a claim, right? If it's not judicial, a government could file an interpleader action and pay that surplus into the court. In other words, we have a responsible entity sort of managing those fees that can oversee the process of addressing the claims that come in. Again, it should be accessible to all claimants, especially vulnerable low-income households. Got to make sure folks know that this thing is out there. Notices, follow-up, continuing to be clear with folks from the get-go that process and how to access it. There are a lot of folks interested in exploring the statute of limitations. How long should we hold that debt in, or that surplus next? And certainly we encourage folks to look into this in their own jurisdictions. We've heard certain time limits put out there. As far as we can tell, the law supporting in statute of limitations on this is very limited at best, but certainly nothing to say that we can't do it at all or explore what that looks like in your own particular jurisdiction. Next. So what are we left with? What specific procedures can we still use to address VAD? And by VAD, we mean vacant, abandoned, and deteriorated properties, right? So it's really clear. Vacant properties should be treated differently by the system. Our hope is that we're not dealing with these properties that we're not worried about foreclosure as much, except for vacant abandoned properties, because we've built a system that keeps those vulnerable owners out of this process. So for properties that are vacant, we definitely urge shorter redemption periods, right? The harm that property is potentially imposing on the people who live next door to it or on the block is really detrimental. And we want to make sure that we get that process moving as quickly as possible. Again, that fully loaded minimum bid is really, really important. Housing and building code liens, particularly those liens that reflect the abatement costs or the costs of boarding up the property or mowing it, removing dangerous dumping of garbage, or otherwise securing the property, or even in many cases, demolition of the property. Those costs should be secured by a lien against the property, and we should be able to have state law that clearly allows for those types of liens, those code enforcement actions, the costs of dealing with the problem that's been left there, should be able to be collected along with this. So therefore, if somebody does redeem or even buys it, at the very least, the local government is getting paid back for their investment in trying to secure that property. All right, so super critical, and I think that's a big area that a lot of states and local jurisdictions should be looking a lot more closely at in the wake of Tyler. Government or a land bank where you have them should definitely have the default bid in the amount of the minimum, that minimum bid for that fully loaded bid. And they should have that in the amount of a credit bid. I use credit bid to say that they don't actually have to pay cash for that minimum bid if that's the highest bid. They should just be able to be recognizing we're going to get it in exchange for all the work we're going to be doing it. We're kind of getting it on credit for that amount that we've already invested. The public has invested. And the government and the land bank or the land bank should have the authority to compete with private bidders if they need to. where they're bidding $1 over that highest bid, but they got to pay cash if there's more than the minimum. And to the extent that there's a surplus, that money should go into escrow or be delivered to the former owner or interested parties. And then lastly, just a reminder that Nelson, so saying, okay, and for vacant properties, you also have to, as an owner, you have to file a request to have a sale. Otherwise, you waive your right to any surplus or things like that. Just a reminder that processes like that are not overruled by the Supreme Court explicitly, but we do point out in that policy brief that there is increased risk. And we certainly encourage our partners to weigh that risk and their appetite for defending future challenges and other things like that as they're considering how to move forward. Next. So that leaves us with our call to action. As we've kind of repeated, or I have repeated, I suppose, several times throughout this, the Tyler decisions really renewed a lot of attention to a lot of longstanding inequities in the property tax system, right? The case itself focused on a narrow aspect of a former owner being able to claim some of those surplus proceeds. But in order to get to the deeper question of equity, it's our position that we need to really focus on that system further upstream to prevent folks like Ms. Tyler from getting to that foreclosure in the first place, right? And we need to really open up our systems and make sure that we are embedding equity, and by that I mean fairness, into the system in the right way. So this Tyler decision presents all states and local governments, even those who may not be directly impacted by the decision in the case, even those that have a public auction in place and have a process where folks, former owners and interested parties can claim surplus proceeds, right? Even where you have that, there's still an opportunity here to create more equitable, efficient, and effective property tax systems. We recognize that what that is looks a little bit different everywhere. The high level ideas for reform we just presented may not work specifically well in your jurisdiction, but it may be that there are elements of that would work. And we really do look forward to working with all of you to think through some of those things as we continue to go forward. And we also look forward to engaging with all of you that disagree, right? That think that there's a different way of looking at some of these things. It's a fun conversation to have. But at the root of it, I want to make sure we remember that, what we're trying to design is, yes, a system that maximizes tax collection so that we can fund basic services to people. That's so important. But we're talking about people's homes. We're talking about people's lives. And if that's not at the center of what we're talking about, then I think we need to hit the reset button a little bit. So that's where I'm going to end it. The next slide, Crystal. We can move into the questions. I want to make sure everybody sees here that we've got my name here. Again, I'm putting Libby's name there as well. If you guys just give me just a quick second, I will go ahead and start to take a look at some of the comments that are out there. And I will, I'm going to start with, well, gosh, now I've got to wade through everybody's name, which is fantastic, by the way, to see so many of you here. Is Tyler versus Hennepin retroactive? That is an excellent question. The answer is most likely yes. Daniel, to the extent that, the Supreme Court is doing it, I would point to Michigan. The state of Michigan has the unique experience of being kind of at the forefront of this issue in a couple of different ways. They already, in 2020, there was a decision called Raffaele LLC versus Oakland County that the Supreme Court of Michigan decided a similar question and found that the Michigan system also didn't provide a similar opportunity for former owners to claim excess proceeds. And so Michigan has been dealing with a whole lot of litigation post Raffaele litigation. They've amended their statute since to put in place a claims process. Again, I'm not going to get into the details too much more, but they are also dealing with a whole lot of claims that are coming out there claiming that former owners had a constitutional right to that excess proceeds. And they are litigating those claims. And I do think that there's validity to a lot of those claims. And, if we look past Michigan into other states, certainly I do think there is retroactivity is going to be a big question. I don't have the exact answer, but I do think it's very possible that that's the case. Let's see, where else are we here? We've got a question from Laura Settlemeyer. Hi, Laura. The implications for code enforcement lien foreclosures. I would argue that this is a very, very similar analysis, Laura, in terms of code enforcement lien foreclosures. To the extent that that foreclosure process does not provide the owner or an interested party with an opportunity to value that property and to claim excess proceeds, then yes, I do think that there is an opportunity to for there to be a Tyler or a potential Tyler claim that could exist for that. And certainly we can go into more detail on that down the road as well. Let's see here. We've got, what funding mechanisms exist for those that have land banks where properties that are high liability do not sell at auction? Julie, that is just an excellent question. And a very broad question. So I just want to make sure I get this correct here. What properties, I'm going to start with the second part here because I think the first question is pretty broad. Where properties that are high liability do not sell at auction, first and foremost, we believe that there should absolutely be a mechanism for either the local government or the local government working with the land bank or the land bank to be able to get control of those properties to the extent that there is an auction and there's no bid, right? They should be able to step in with the bid to be able to do that. But as your point points out, land banks are going to need funding to be able to handle these properties that essentially the market has rejected. Many cases, these properties are going to need a significant influx. I will say that I don't know of any state that has solved it perfectly well. We often point to the state of Ohio, which has done an excellent job. And the state of Ohio has some really creative, really smart folks throughout the state, in Cuyahoga County and Lucas County and Franklin County, all over, who have really thought this through. A percentage of what they collect through the delinquent tax enforcement process does go to fund land banks. That's helpful. But otherwise, land banks across the country are cobbling together a range of things. They're more increasingly looking to states for more reliable funding. They are increasingly looking for opportunities to, get into some of the development options that are out there and connecting to some of those things that are out there. Although in weaker market jurisdictions, that can be hard. So we've got some good material out there. I don't know if any of my colleagues have linked to this in the chat, but there's some good material out there that Community Progress has put out about land bank funding that certainly we'd love to chat with you a little bit more about. By the way, there are some excellent questions in here. And so if I do skip over some of these, apologies. Libby, thank you so much for starring some of these questions. Incredibly helpful to help sort through some of these. So for properties that are being pulled from auction for demolition, should appraisals be done to prove negative value? Gina, that's a really good question. I need to understand a little bit. I need to be reminded maybe of the jurisdiction that we're talking about here. So is the local jurisdiction sort of pulling this from auction in advance of a particular sale, and then what's happening after that? But I would say that at the minimum, an appraisal should be done to prove some sort of negative value. But I would say also that probably doesn't completely insulate you from a potential claim for Tyler. And again, I'm not saying that the public auction is a foolproof way of doing everything, but to the extent that that's a problem. The other question I would have is, how are you doing demolition, right? Is it that we're doing demolition and then putting a lien against the property? In which case maybe the demolition could be done and then the property could be offered at that foreclosure auction post-demolition with the lien reflected in that minimum bid. Again, I don't know the state law right there off the top of your head, but there's a lot of things that are bouncing around in my head as ways that we'd think about that. Let's see here. Next. Theo, in your opinion, should states with tax lien systems begin thinking about changing statutes proactively in response to this case, or should they wait for the case law to become a bit more settled? Theo, I'm biased. I want to tell you that right off hand. I tend to think that the sale of tax liens is not always the most efficient system, and particularly, as I mentioned earlier, in the context of vacant and abandoned properties. I do think that there is nothing preventing states who have those systems in place to begin thinking about whether or not that is still the most effective system post-Tyler, or whether or not there are alternative options. Certainly, there are going to be a range of folks who disagree with that on a policy standpoint. I'd point you to some of what we've written on this subject, and some of the harm that we believe the sale of tax liens can have. I don't think necessarily that states should wait for the case law to become a bit settled to begin thinking about this particular question. Sam, can you talk more about the implications for tax foreclosure systems that don't utilize public auctions, such as systems that transfer title to the land banks, who then select a new owner based on applications that include reasons other than sales prices? Should those systems go back to auctions? That's a big question. So we talked earlier about the definition of strict foreclosure, right? And I think that the case leaves open an option where if you have a system of strict foreclosure, but then auction off the property, that there's a potential defense, though the public auction at the conclusion of the sale is probably the cleanest way of saying it. I'm not troubled by, but I'm trying to wrap my head around the select a new owner. I get the choice of words there. But I think that the calculation that goes into transferring the property out of the land bank is more of a process set in place by larger community-led policies, and that the consideration that we're talking about just takes a different form for that purpose, but maybe that doesn't change one way or the others. Should those systems go back to auctions? I do think that probably going back to an auction is going to be the safest bet. But there's going to definitely need to be analysis on the jurisdiction's appetite for risk, to the extent that they think Nelson is a defense. I would want to, think real hard about, is that the right thing? Could we do a request sale provision? And I'd want to think real hard about how that exposes that jurisdiction. I don't think that once a land bank gets title to it, they should change that process necessarily. I think that to the extent that the land bank gets title to the property, maybe it's after that property has been subjected to a public auction, and then the land bank gets title to it. I don't think the process of how the land bank sells that property or transfers it to a new owner should change, because I do think there are way too many community priorities and needs, and land banks continue to have the flexibility to do that. But there probably does need to be some process in place for there to be evaluation, and then for former owners to claim any excess proceeds on that. All right. So it sounds like there's a big discussion going on in the comments here. I apologize, I'm not going to be able to get to all of these comments or questions. I think we have time for at least one or two more. Trying to get these here. I apologize. So Matt, I understand your perspective that Tyler is likely retroactive. However, are states able to provide a framework for some kind of reasonable timeline or statute of limitations for past takings? Matt, I will go back to my earlier comment. This is a huge question, and one I will be quite honest with you, I'm not prepared to answer in this conversation. I think it's worth pressing that issue a lot more and examining it. Again, I pointed to Michigan earlier as somewhere to sort of, they're dealing with a lot of these cases, and some of their claims post Raffelli within their own state are at a different stage, and some of their lessons learned might be really instructive in terms of whether or not there is some kind of a statute of limitations for past takings. But my understanding of the law is that it's not super developed, and I'm not quite certain that there's been discussions of, is it 6 years? Is it 7 years? We've heard a lot of those kinds of comments out there. I just want to be sure to be clear that I don't have the answer for that right now, but I think that that is one question that needs a lot of follow-up analysis. Certainly, we're willing to engage in that conversation down the road, but for the purposes of this webinar, we really are focused on the prospective. And Matt, I look forward to meeting you soon. Pat, are these dangers, and I'm trying to get what we mean by these dangers, but similar to the local, if the local government transfers the property to the municipality's urban renewal agency, so a separate entity. I think that depends. Again, what we're talking about is potential liability for an amount of money, right? And the question then is going to be, if there is a post-Tyler challenge, who's on the hook to pay that money? I think it's quite clear that the foreclosing entity is probably the most likely one on the hook. But I do think that to the extent that the property was transferred, so say the property was not foreclosed, it was a strict foreclosure and then transferred to $1 or for free for $0 in recognition of the work they're going to do. I want to be clear there, to a municipality's urban renewal agency, right? And then down the road, the urban renewal agency, renovates the property, does things, and then sells it for an amount that exceeds whatever that last amount was. There's certainly a question of whether or not there was some value in there. There's lots of questions around, what value was added by the URA's involvement in that process and things like that. So I think that you don't necessarily absolve the question of, is there liability out there by transferring it to another entity? To the extent that it's about the money, the question is certainly, I think the original foreclosing entity is going to be potentially on the hook, but that could go down the line as well. So in terms of who has to pay the money or pay the money back. Again, a lot of these questions, and I get it, are focused on a lot of the risk, a lot of the things that could happen. I do think too, though, that there's a lot of positive things that can happen as well, right? This is an opportunity to really think hard about this. I do want to point out that, in a lot of these cases, if we do it right, if we design that system right, particularly if we really design that system to make sure that minimum bid is truly reflective of the public's costs or investment in that property, right? I think we have some real opportunities to pull properties away from that. And certainly to the extent that some of our partners have a larger appetite for, defending some of their processes in place, I think that's great. Would love to hear more about what they're thinking about doing down the road. And I think that it's definitely something to follow and see where that goes. Sorry, just a couple more questions here. I'm going to answer, I think, just one more. And I'm going to go to Baxter here. So considering the municipal lien foreclosure system for the city of Mobile, Alabama, which includes a public auction at the tail end of the process if there are no bidders and the city is the bidder of last resort, would the price, which is fully loaded, essentially set the value to help determining the surplus? I think I understand what you're asking there, Baxter, and I think that there is... and I'm not a complete expert in these fields. There are other lawyers who are fantastic in this area, who have a deeper understanding of mortgage foreclosure law and other areas. But I think there's a case to be made that if the property is offered at the public auction and it includes all of the realistic debt that is owed to that jurisdiction, right? That, at the very least, a public auction itself is going to be to generate that bid. So if nobody bids on it, Baxter, I would say that you look back to it as a debt collection tool, and you can take the property in satisfaction of that amount that was owed. So I think, though, that it does sort of help to set the value in determining the surplus. And in that case, there would be no surplus in the foreclosure action. And so taking title to the property in that case would make sense. I think I got the answer. I think I got your question right, and I hope I did. If not, please follow up with me separately, and we can chat about that. And then I think that's about, sort of looking at everything else that we've got here, I think that's about what we have time for at the end of it. There are a few more questions that were in the comments. A lot of questions. I realized that we only touched or scraped the surface of a lot of the questions that are out there. I want to reiterate, if you want to put up again, Crystal, maybe that slide with Libby and my email. Certainly you guys are going to get a copy of this stuff. So if you need to get a hold of us, please do. There's going to be lots of questions about this. There will continue to be. We are here to kind of help think through this. I think it's a lot easier when we know the specific parameters of the state statutes and the local enforcement system to sort of engage in these conversations one-on-one. Our hope is that this, both the policy brief that we put out and this webinar, provides you at least a starting point to begin to think through, like, oh, I hadn't thought about that question, or yeah, how do we answer that? Or maybe this is a really good opportunity to take a moment and think through, like, we seem to be getting a lot of lower income folks heading towards the foreclosure process. How can we stop that? And then ultimately, the questions about how we deal with vacancy and abandonment. This case, I want to be honest, it does introduce some real hurdles. Things like right of first refusal in Michigan, where the local government can pull those properties out of the auction. There's now more risk associated with using those procedures. And I want to make sure that we get that. But we still think that there are ways that we can address some of those problems. Not all of it. Some of the work will be harder. Some of it, I think we can use this as an opportunity to improve the entire system. So thank you all for tuning in today. Thank you very, very much. I appreciate all of you and all the work that you do. I really appreciate my colleagues for continuing to support this conversation and continuing to put us in a position to be able to work with all of you on these issues. So without further ado, I think I will go ahead and say thank you. And I hope you all have a wonderful rest of the week. And I look forward to connecting with many of you one-on-one going forward.
Thanks for joining us this afternoon. Please visit our website at communityprogress.org and join our listserv to stay up to date on webinar announcements. Have a great afternoon, everyone. Thank you.